Welcome to While We Were Distracted, the podcast where we explore topics that often get overshadowed in the rush of daily life.
If I told you a lawsuit was worth $150 billion, you would probably assume the trial would take months, right?
Oh, absolutely. You'd expect it to go on forever.
Right. I mean, you picture mountains of meticulously labeled evidence boxes and, grueling cross-examinations and this agonizingly slow deliberation process.
Yeah, the classic cinematic courtroom drama.
Exactly. But what if I told you it took less time to dismiss a case of that magnitude than it takes to, watch a movie?
Yeah, it genuinely redefines the concept of legal whiplash.
It really does.
You have an unprecedented dollar amount attached to claims that challenge the structural foundation of the whole artificial intelligence industry.
Right.
And, it all just hits a brute wall at the speed of basically a routine traffic court hearing.
Which is wild. So today we are bringing you a deep dive into the abrupt total dismissal and the massive pending appeal of Elon Musk's lawsuit against OpenAI and its CEO, Sam Altman.
It's a massive story.
It is. And to guide us through exactly how that happens, we are drawing directly from our sources today. We are pulling excerpts from an incredibly detailed article titled Musk v. OpenAI, the Battle of the Appellate Calendar.
That's a great piece.
It really is. And we're looking at that alongside extensive Reuters coverage of the trial itself and the actual Ninth Circuit court docket to track the current appeal.
So we have all the actual documents.
Exactly. Our mission today for you, the listener, is to map out how a staggering $150 billion case gets thrown out by a unanimous jury in under 2 hours.
Just unbelievable speed.
Right. And we'll look at what it means now that the fight is moving to a higher court. Okay, let's unpack this.
Well, I think we have to start with that jaw-dropping time frame.
Yeah, the 2 hours.
Exactly.
Yeah.
Less than 2 hours of deliberation by a federal jury. I mean, that is barely enough time for 12 strangers to introduce themselves, pick a foreperson, and, review the introductory instructions.
Seriously, you'd barely get through the introductions.
Right. Yet in that tiny window, they reached a unanimous agreement to dismiss a case that carried industry-shaking implications.
So how did they do it so fast?
Well, they achieved that speed because they never actually evaluated the artificial intelligence dispute. They evaluated a math problem.
Right. They evaluated a statute of limitations technicality.
Exactly.
The jury basically looked at California's strict 3-year window for bringing corporate restructuring claims to court. And, Musk's entire lawsuit hinged on the timeline of OpenAI's corporate restructuring.
Yes.
So the jury simply determined that the clock had run out before the paperwork was filed.
What's fascinating here is how fundamentally that calendar check alters the traditional job of the jury.
How so?
Well, we are conditioned to view juries as arbiters of complex narratives, right? We think of them sifting through competing versions of reality to uncover the truth of an allegation.
Yeah, weighing the evidence and all that.
Yeah, exactly. But in this specific instance, that vast responsibility was distilled down to just subtracting the date of the underlying event from the date of the legal filing.
Wow. Just a simple equation.
Yeah, and the result was greater than 3 years. So, under the strict parameters of California law, that single calculation closes the case completely, regardless of the $150 billion stakes.
I'm trying to visualize the sheer frustration of being on the losing side of that dynamic.
Oh, it must be staggering.
Imagine you discover an old lottery ticket in the glove box of your car.
Okay.
You pull it out, you check the website, and the numbers are a flawless match for a $150 billion jackpot.
A literal fortune.
Right. So you rush to the lottery headquarters, heart pounding, slapping that ticket on the counter. But the cashier doesn't even look at the numbers.
Oh, man.
They just point to the timestamp at the top and tell you the ticket expired yesterday.
Let's take that lottery ticket scenario a step further to really capture the courtroom dynamic.
Okay, go for it.
It is not just one strict cashier at the counter. It is a panel of 12 cashiers. The jury, who spent their 2 hours sequestered in a back room solely to verify that the expiration date was in fact yesterday.
That's a great point.
And they are explicitly instructed by the judge not to verify if your numbers match the jackpot. Their only mandate is a calendar.
Which means the actual substance of Musk's lawsuit was entirely ignored by the court.
Completely untouched.
The underlying allegations were never ruled on, and because of that, we are left with this massive unresolved tension in the tech world.
Right.
You have OpenAI's legal team celebrating a complete victory, successfully defending their client and their corporate structure against a monumental threat.
Yeah, they are thrilled.
And then meanwhile, Elon Musk is taking to X, blasting the entire verdict as a mere, quote, calendar technicality that avoided the truth.
The split screen between those two reactions is wild. It really highlights the core unruled allegations that are kind of haunting this outcome.
Yeah.
Musk's central assertion, the claim he was demanding the justice system evaluate in the first place, was that OpenAI executives inappropriately enriched themselves.
Right, the financial claims.
Exactly. The specific mechanism for this alleged enrichment, according to the lawsuit, was the controversial conversion of OpenAI from a strict nonprofit organization into a capped for-profit entity.
And we should be incredibly clear for anyone listening that our goal on this deep dive is not to litigate those underlying claims.
No, definitely not.
We are simply reporting the facts presented in our source material. So fact one. Musk leveled massive allegations of inappropriate corporate enrichment via this restructuring.
Right.
Fact two, OpenAI secured a total unanimous legal victory shutting down the lawsuit. What we do not have and what the tech industry was desperately waiting for is a judicial ruling on whether that transition from nonprofit to for-profit was actually improper.
Yeah, the justice system has officially taken no stance on the mechanics or the legality of that corporate pivot.
No, which is a huge deal.
It is. This raises an important question. What happens to our societal understanding of corporate accountability when a massive allegation of structural enrichment is left completely untested due to a rigid time limit?
That's the million or billion dollar question.
Right. The tech ecosystem was anticipating a merits-based ruling. They wanted a definitive legal judgment on the restructuring of the world's most prominent AI company.
Instead, they received a purely procedural ruling based on a ticking clock.
Exactly.
You know, I have to push back a little on how Musk is framing this on X, calling it a mere calendar technicality as if it's some sneaky loophole.
Sure.
If I put myself in the shoes of a business owner, a statute of limitations seems like a desperately necessary legal boundary.
It's foundational.
But surely, I mean, if the stakes are $150 billion, doesn't a federal judge have the power to look at that ticking clock and say, the public interest in evaluating this AI technology outweighs a standard filing deadline?
You would think so, right?
Yeah. Like, does the system allow for that kind of override, or is the clock absolute?
Well, the system is deliberately designed to prevent that kind of override, regardless of the price tag or the public interest.
Really? No exceptions.
Essentially, no. Statutes of limitations are a foundational pillar of the legal framework for a very practical reason, and that is the degradation of reality over time.
Oh, like evidence degrading.
Exactly. Evidence goes missing, digital trails get overwritten, human memory is notoriously unreliable, and witnesses eventually pass away.
Right.
If judges could just wave away a statute of limitations simply because the dollar amount is staggering, the concept of legal finality would completely collapse.
Because without that boundary, corporate disputes could literally drag on forever.
Literally forever.
You could have a competitor suing you for a boardroom decision made a decade ago, forcing you to defend actions where the evidence barely exists anymore.
Right. Companies would be paralyzed.
Yeah.
They would be forced to hold massive cash reserves in perpetuity, constantly bracing for lawsuits regarding decisions made by previous generations of leadership.
That makes a lot of sense.
The law places a premium on finality. It dictates that if a party has a legitimate grievance, they carry the burden of bringing it forward while the trail is still warm.
Use it or lose it.
Exactly. Society trades the opportunity to hear the merits of some older, potentially valid cases in exchange for a functioning business environment that isn't, trapped in a state of perpetual legal jeopardy.
So the system explicitly values the ability of society to move forward more than it values a plaintiff's right to wait around before bringing a claim.
That's the trade-off.
I understand the logic, but when the allegations involve the foundational architecture of the company leading the global AI race, it becomes clear why Musk is refusing to accept that trade-off and just walk away.
Oh, absolutely. He's not dropping it.
He knows his actual claims were left entirely unexamined, which is why he's taking this fight to the next judicial tier. His legal team has officially confirmed they will file an appeal.
And that appeal is heading directly to the Ninth Circuit Court of Appeals. The strategy outlined in the Reuters coverage in the appellate docket indicates Musk's team will focus aggressively on that exact gap between the calendar and the claims.
So they are going right for the technicality.
Exactly. The specific grounds for the appeal will argue that the trial judge and the jury fundamentally failed to rule on the actual merits of the case, specifically the nonprofit to for-profit conversion.
Now, I am stuck on how difficult this next phase is supposed to be for him.
It's going to be very difficult.
The legal analysts quoted in our sources describe Musk as entering this appellate process as a distinct underdog.
Yeah.
And, I mean, he has functionally unlimited capital and access to the best legal minds on the planet. Usually, unlimited capital means you can eventually force the legal system to address your core arguments.
Usually, yes.
Why is a timeline issue the one wall his resources might not be able to break down?
If we connect this to the bigger picture, the underdog status comes down to the strict division of labor within a federal courtroom.
Okay, break that down for me.
You have two distinct roles. There's the judge, who determines the law, and the jury, who determines the facts.
Right.
Appellate courts, like the Ninth Circuit, are not designed to host a second trial. They exist almost exclusively to correct mistakes of law made by the trial judge.
So just legal errors.
Yes. If a judge misinterprets a legal precedent, issues the wrong jury instructions, or misapplies a statute, the appellate court steps in to correct that legal error.
But the hurdle here is that the jury determining the 3-year clock had run out, that wasn't a legal interpretation by a judge.
No, it wasn't.
It was a factual finding by 12 citizens.
Exactly. The application of the statute of limitations in this specific trial was presented as a question of fact.
Ah.
The jury was handed a timeline and asked a direct question. Did more than 3 years pass between the triggering event of the corporate restructuring and the date the lawsuit was filed?
And they said yes.
Right? Acting as the designated finders of fact, the jury unanimously answered yes. And appellate courts are historically, structurally allergic to overturning a jury's factual findings.
Because the appellate judges weren't in the room.
Exactly.
They didn't watch the witnesses testify about the timeline. They just have, what, the transcripts?
Just a paper record.
So they defer to the 12 people who are actually there observing the evidence.
That's it. Overturning a factual finding requires a significantly steeper climb than pointing out a judge's misreading of a case law precedent.
It makes sense.
The Ninth Circuit is heavily restricted in its mandate. They review for procedural or legal errors.
Right.
If the jury was legally permitted to evaluate the timeline, and they made a factual determination that the timeline had expired, the Ninth Circuit's job is not to ask if that decision was fair to the underlying AI allegations.
So fairness doesn't even factor in.
Not at this level.
Yeah.
Their job is simply to ensure the legal parameters around that jury decision were sound.
Wow. Okay, here's where it gets really interesting. From Musk's perspective, he is basically throwing the red challenge flag on the field, demanding an instant replay.
That is a perfect way to look at it.
He wants the officials in the appellate booth, the Ninth Circuit judges, to look at the monitors and see the substance of his claims.
Right.
He wants them to say, look at the massive foul that occurred. Look at the inappropriate corporate enrichment.
Yeah.
But the problem with his challenge flag is that the monitors in the replay booth aren't allowed to show the actual play on the field.
Exactly. The replay officials are restricted to looking at the stadium clock.
Just the clock.
Yes. If the stadium clock clearly shows the quarter expired before the play in question even happened, the officials cannot throw a flag for the foul, no matter how egregious it might look on a different monitor.
It could be the worst foul in history.
Doesn't matter. They are bound by the rules of the game to confirm that time had run out, rendering the subsequent action legally void.
So what does Musk's legal team actually have to prove to win this appeal?
It's a narrow path.
Right, because if they can't argue the underlying facts of the AI restructuring, and they are fighting against a unanimous jury finding about the calendar, what is their path forward at the Ninth Circuit?
Well, their path requires convincing the appellate court that the jury was legally wrong to apply the calendar the way they did.
Okay, how do they do that?
They cannot simply argue that the jury was harsh. They have to argue that the timeline mathematically started later than the jury calculated.
Ah, shifting the start date.
Exactly. Perhaps by claiming the, quote, injury of the restructuring wasn't fully realized until a later date.
Right.
Alternatively, they could argue there was a valid legal reason the clock should have been paused or told during that 3-year window.
But again, they are trying to convince appellate judges that 12 citizens who took less than 2 hours to reach a unanimous verdict somehow got the math completely wrong.
Yeah, that's the uphill battle.
The sheer speed of that 2-hour deliberation suggests the jury didn't find the timeline ambiguous in the slightest.
Not at all.
It suggests the expiration date was overwhelmingly clear to them. And I imagine the Ninth Circuit takes note of how quickly a jury reaches a conclusion.
Oh, definitely. The speed of the verdict heavily insulates the factual finding.
It does.
It telegraphs to the appellate court that this wasn't some borderline call that the jury agonized over for weeks. It was viewed as straightforward arithmetic.
Right.
And that is the stark reality of high-stakes corporate litigation. It rarely resembles the cinematic courtroom dramas we consume.
So true.
It is deeply technical, relentlessly procedural, and bound by structural rules that are entirely indifferent to the narrative drama or the dollar amounts involved.
The battle of the appellate calendar. I mean, it sounds like the most boring clerical dispute imaginable.
It really does.
But we are looking at a $150 billion fight over the ethical and structural future of artificial intelligence. And the entire thing is currently hanging on how a panel of judges interprets a stopwatch.
It strips away all the grandiosity of the tech industry's ideological battles, doesn't it?
It really does.
And replaces it with the cold mechanics of civil procedure.
Yeah.
You can assemble the most expensive legal team in history, marshal unprecedented resources, and file claims that strike at the heart of the modern technological revolution.
Yeah.
But if you fail to navigate the mundane reality of filing deadlines, the judicial machinery simply shuts down.
So what does this all mean? Why should you, listening to this right now, care about the intricacies of an appellate strategy over a billionaire's dismissed lawsuit?
It's a fair question.
The takeaway here is incredibly practical, regardless of whether you are navigating a massive corporate empire or just managing your own daily affairs.
Absolutely.
In the world of high-stakes maneuvering, knowing exactly when to fight is legally just as critical as knowing what you are fighting about.
Maybe even more critical.
Exactly. You can possess the most righteous cause imaginable, backed by mountains of undeniable evidence, but the most consequential disputes in the world can hinge entirely on a rigid calendar window.
Yeah.
The clock, ultimately, is the highest judge in the room.
It forces a recalibration of how we view justice in the corporate sphere, really.
It does.
And it leaves us with this final lingering question to consider. If a $150 billion dispute over the ethical and financial restructuring of an organization actively building technology designed to alter the course of human history, can be entirely silenced by a ticking clock.
Right.
What does that say about how corporate accountability is ultimately governed by the rigid constraints of the calendar rather than the fundamental truth of the allegations themselves?
That is a lot to think about. A huge thank you to everyone for joining us on this deep dive. We will see you next time.
Don't forget to like and subscribe for the next episode on While We Were Distracted.